do I point at? So just quickly, I wanted to do a little overview of the services that we provide. Again, most of you are probably quite familiar with what services we have, but for those of you that aren't, we have legal information, legal advice, which comes generally in the form of duty counsel, as well the family law line over the phone, and legal representation if a client is approved. But we also have, which I have in my little notes here, a newer service, which you may have heard briefly about this morning. We have criminal justice navigators. So some of you may be familiar, what am I doing? Some of you may be familiar with, of course, there's some family law navigators around, correct, with Rise. So we will have criminal justice navigators starting hopefully in the near future. And what this program is, we'll have 8 spread around the province at some local agent offices. I'm going to put this thing down because I'm not actually touching it. We'll have 8 around the province at various local agent offices, and then we'll have 2 based out of Vancouver. And the criminal justice navigators are that extra set of hands for criminal clients only, assisting largely duty counsel. Figuring out if somebody's got legal aid or not, who the lawyer is, liaising with the local agent office or one of us at head office. But really it's that extra set of hands on the ground, potentially roaming around the community. So they may not have a fixed office. They may be at the courthouse a lot, depending on the location and what resources are already available. We've planned, the locations were chosen based on sort of existing framework. So there's a local agent office where they can be sort of supervised on a day-to-day by the local agent lawyer. And there's already some key people in the community that they can connect with. And then as the program grows, then we can add more locations, assuming, it's a big hit and we get more money. So that's just a brief. Right now we have 1 navigator that has started in Nanaimo, who's just currently being trained by our fabulous office there, Denise Barry, and Hasey, who is our intake worker there. And then we hope to have the other 9 coming soon. Now we will skip forward. Applying for legal aid, I think I'm going to hand it over to Shannon here, and she's going to speak to that.
Hi. So I'm Shannon. This is my first conference here. I've been in intake for 6 years now. So I was doing applications, and I've recently just this year moved into the training and online applications position. So I'm really excited to be here just to see some faces and get some idea of where some of these online applications are coming from. So I'm talking about ways of applying for legal aid. So I'm going to focus on the online applications part of it, but just touching base on the phone lines. What we have here, the top, well, I guess in the middle are the ones in blue are just our regular call center phone lines. Anything is on a timer. So Kirk, it wasn't you. It's automatic. The numbers in blue can be given to clients. Anybody can phone those numbers and they go through the call center. The number below where it says CP line, so that's our community partner line. That's our line that advocates can use when they're with clients. It has a slightly higher priority than the regular call center line. So the idea being that you're not sitting on hold for as long. So hopefully you can get through a little quicker if you're helping your clients to apply. So if you want to take note of that number, please don't give it out to clients, but it can get you through the call center a bit faster. I'm not sure if we've kind of spread the message, but our call numbers have just doubled in the past year. So over the past year, we've gone from averages of around 200 calls to closer to 400. So that's also expanding some of our call wait times have been so high. We are working on that. We're doing a number of different things to try and get through all of those calls when we can. And so then the number underneath is the same number, you'll notice. So that's the number for the immigration as well as for the CP line. And I think you just have to make a selection when you go through. All right. So now what I'm actually going to do, I'm going to ask Alex, if you could click on that link. And we're going to actually go to the website so that I can just show you where the applications are, just in case anyone isn't aware. They are just on our website in the community workers tab down to client services. And then if you scroll down and you get to electronic legal aid applications. So currently we only have family law applications in there. I am working very hard to get all areas of law in there. I think we're probably going to end up doing immigration first, which seems a little bit backwards. But I'm hoping to have immigration applications in there by the end of this year, and then criminal and child protection applications early next year. So in the first quarter of next year. So you will be able to help clients and send in online applications for clients for all areas of law that we cover in the next 4 to 6 months, I'm hoping. So if we can open up the legal aid application, and I'm just going to go through, I'm not going to go through every section, but what I'm hearing is that there's some confusion about what information we really are looking for. And I just need to be on the first page. I will say that in all of the applications, the first 2 pages are going to be about the same. So your immigration application, your child protection, your criminal, these first 2 pages are going to be the same. And it's because the first page is basically our client profile page. And then the second page is just finances. Sorry, Alex, we're on the second page. Can we go to the first? Thank you. I'm just going to come out here so I can see it a little better because I can't see it on my screen. So this one, most of these sections are sections we need completed. I think most of it is pretty straightforward. First name, date of birth are obviously necessary. Gender is one of the fields that's required for us. We do like to get Indigenous ancestry if we can. That's based on how the client self-identifies. But we do have an option that if they don't want to respond to that as well. Yeah, absolutely. No.
There we go. Now it's working. So when I'm doing gender, because male and female and other can feel a little bit weird to say, and those are like sex, versus what we're usually talking about is gender. So I do just say women, men, like, do you identify as a woman? Do you identify as a man? Or do you identify as trans, non-binary, or gender diverse? And so I just put my own language on there. I don't always use their language. And I think as long as we're doing things in a way that feels good for us, that's the important thing.
Yeah, as long as the information that you're getting to us is reflected in the form. And our system, we've actually updated to man, woman, and non-binary, I think.
Sorry,
and so yeah, I think we'll likely be updating these forms as well to reflect that. Sorry, Alice, we're on the second page again. Can we go back to first? Thank you. Address, if they have an address, if there's not an address, NFA is fine if there's no fixed address. But a city is really helpful if we can get that. If they have any contact information, that's great. You'll see down below that where it says consent to be contacted for the survey. There's no penalty for them not consenting to that. So,
and I tell clients that I say I have no investment in it, but I do also tell them that I think legal aid really is interested in hearing about how the third-party applications are impacted. And some clients go, oh yeah, like this was actually really helpful to be able to do it with you. So I would like to be able to tell that to legal aid. So I do like to tell them that this is what it's going to be used for and how it's going to be used.
I'll also point out that it's consent to be contacted for a survey, so they're not consenting to take a survey. It's just allowing us to get in touch with them in the future and ask if they want to complete a survey. We also have, is it safe to contact the client? So letting clients know that we may be contacting them. If it's not safe to do so, make sure that you're checking that off. And if you're doing that, it's really important, if you can, to get them to send in, or to send in with them the authorization to disclose information, allowing us to contact you instead. You may have a better way of getting in touch with the client, a safer way, or you may just be in constant communication with the client, and able to get information that we can't. Yeah. And yes, so can we contact them? Can we leave a message? That's also important. So for some people, it's okay for us to phone them, but if we leave a message, that message may be picked up by somebody. So those are two areas that are very important. If we look to the top right where it says ID type and ID number, that's not important. We don't need that information. If they have a social insurance number and they're on social assistance, that can be helpful information for us to have, but we don't require that the client provide any form of ID. Highest education, if we can get that information, it's helpful. Again, it's not the highest on our priority list.
I do tell clients that legal aid sometimes asks dumb questions, and they're allowed to ask me why a question's being asked. I say that right at the outset, and this is one of the ones I'm like, technically, apparently it's to try to keep track of the education level for PLEI materials. And so I do tell clients that if they ask, but I do open with legal aid sometimes asks dumb questions.
Thanks.
Yeah.
It's a dialogue.
And then we have the languages and special needs, and that one is fairly important. If the clients, especially if they speak no English, we need to know what language we can communicate with them in. But also special needs, a lot of our coverage can be expanded in certain cases of special needs. So if they have any barriers to representation, please try and put it in there.
I'm going to say a couple words on that. This is why I'm here, was literally for this question. So when I talk to clients, I don't just ask them, like, do you have any barriers to self-representation? I tell them, can you tell me what it would be like if you had to go to court and self-represent? Do you have any physical health issues? Maybe something with your heart, maybe something with your body, a chronic health condition, or a mental health issue, you know, especially for people who've experienced intimate partner violence, there might be ongoing anxiety or depression. And then I ask them to tell me what it might be like. You know, they might go, oh yeah, I'd be super anxious. Well, what does anxiety look like in your situation? Anxiety for some people might mean I can't listen to what anybody's saying and I'm just going to be focused on getting out. Other people are like, I literally can't make my way to court. And then I put that, and so that little box is C below or C attached. And then I write out exactly what it's going to be like for my client to self-represent.
And again, that information is very helpful for us. And then the last box in there is just a summary of the legal problem. So for family law, if you can give just a brief summary of what's been going on and why are they seeking legal aid? For other areas of law, that box becomes less important because that information becomes really obvious in the application.
And for me, I fill that box up very last because I can usually collect a lot of other information in the rest of the form that will inform me. Even if I've already got a lot of background, I find that the questionnaire itself actually pulls out a lot of other information. So I go to that one last.
I've got a couple of questions.
Oh. I'm going to run the microphone.
That's okay. I've never spoken into a microphone. So for the languages part, if a client does need an interpreter, by putting their language needs there, do they automatically, when they get approved, also have their interpreter fees covered?
That's a good question. So there are interpreter fees in all of our contracts. So lawyers can always bill for interpreter fees. We use that more for our application purposes. Also, if we're looking for a lawyer for the client, if there is a lawyer that speaks that language, we can check with that lawyer first. So those are sort of the ways we use it.
But yes, if they get approved for a family lawyer, and if they need an interpreter, the lawyer can bill LABC for interpreter services.
I think that's the first page. We're good. So if we go to the second page. So this is financials. I know these ones can be difficult. The financials is certainly an area where intake struggles the most. So I wanted to take a little bit of time on this one. Household size is an important number. What we're looking for is, do they have any dependents, and do they have a spouse? So that can be a common law spouse that they've lived with for 2 years or have a child with, or somebody that they're married to that they're still with. So that's why we've got the household size and who they're with, so that we know who we're counting in the household size. If we are counting another adult in the household size, we have to count their income as part of their income as well. Although I think we have it as a separate line at the bottom. Yeah, so we've got spouses line at the bottom. We don't actually have a space for you to put an amount, but we do need an amount for that.
Can I add a note?
Yeah.
Sorry, I don't want to jump in on your presentation. But I just, about the spouse, I think we see it a lot with the family law area a lot. So of course, if the person is applying to get a lawyer because they're wanting to leave the home, we're not going to ask for the spouse's income. We're not going to include the spouse's income or the spouse's. I mean, we might try to get a general idea of the household assets and that kind of thing. But if we're taking a person's application and there's domestic violence, anything like that, we're not going to ask, even if they still live in the same home, we're not going to bother getting the opposing parties' financial information. They're not included in the financial.
Yes, so we wouldn't include them in the household size, and we wouldn't count their income. So that's where we get some clients who may possibly their spouse is the main breadwinner, and maybe their only income then becomes the child tax benefit, or maybe they have no income of their own. That's okay. We just need kind of that information.
And for me, I do a lot of cover sheets. So anything that I think is a little bit gray, or where I think like numbers, like for instance, somebody that might be pregnant, I will say household size of 2 because it's a woman that's pregnant with a child. And then I let legal aid figure out whether or not I'm accurate when I do that math. But I explain on the cover sheet that she is pregnant and needs to put together her household for the second child.
Yeah, so the question was, if they're with a new partner, do we include that new partner's income? And yeah, we use 2 years. So if they're living together for 2 years, we consider them common law. Prior to that, we would just consider the client's income.
My question here is around like the marital home and marital assets. And are those included if a woman's fleeing violence and now doesn't have access to the home or marital assets? But I've seen them kind of be included in their applications for legal aid, and the woman really is out of the home. She doesn't have access to any of these assets, but they're still included in this. How do we get around that?
So we do like to know that they have assets, that there are marital assets, but please let us know that they're marital assets and that they're subject to proceedings, because we can override them. So it's important for us to know about them, because once the assets are divided, if the client receives a cash settlement as part of it, some of that settlement is used to repay their legal fees. That's part of our terms and conditions. So it's all sort of in our contract. So you can refer to that for more information. But so it's important for us to know about them, but we can override them.
And again, that goes back to that cover letter, explain. I like what I really like about working with legal aid is that they do have a lot of discretion. And I think as long as it makes sense to us and is in the spirit of legal aid, everybody that I work with at Legal Aid, for the most part, has a lot of that, like this is in the spirit of doing what's best and people that can get through. So I think writing whatever makes sense for that situation is always a good option.
Yeah, for the most part, more information is better. We've got lists of suggestions of income types, suggestions of allowable deductions. For deductions, I say the main things we see are daycare expenses and medical expenses. So if they have regular monthly medical expenses or monthly daycare expenses, please do include that. And then the income type obviously we're not ever going to see clients who have all of those incomes. It's just an idea for suggestions, but most people, if you ask them how they're supporting themselves, they're able to kind of respond to that, and you can just find it in there. And then for assets, obviously there's not always going to be like charges owing. What we're looking at mostly are houses, savings, vehicles. Is that about it? Missing any big ones? RSPs, sort of savings types.
Do you have an equity level for a vehicle, or is the first vehicle exempt?
So the equity level for vehicle is 15,000 for a family vehicle. There are some situations where we can exempt it, but that's our base amount at this point. 1.5, sorry.
What about in the scenario that a client is fleeing their partner and they're now living with their parents? And so are they now all included in the household size?
No.
No. Okay.
Short answer is no.
For repaying, oh, thank you. For repaying legal aid after receiving a settlement, is that guaranteed or is it case by case? And like, how is that determined?
It's a good question. It's determined on a case by case basis, but basically we consider them retroactively no longer eligible for legal aid. And so they're only repaying what legal fees they've used, but it goes up to the amount of their asset limit, is my understanding. If that makes sense.
There's no equation that's
No.
used. So people believe that, and I think in some provinces, there is an equation that their audit department, we have an A&I department, and Gabriella is she works on the collections. So the lawyers or the clients sometimes will let them know when there's been a settlement. And then depending on, like Shannon said, the amount of the settlement and the amount spent on legal fees, LABC may have spent $3,500 on a case. If they only received $4,000 in a settlement, chances are they may not have to pay back that $4,000. But again, there's no specific equation, so it is case by case. Yeah.
Okay, thank you.
Sorry, if legal aid determined that a woman is owing money to you for whatever reason, and they don't feel that they do, is there a way that they can dispute that?
So yeah, they can contact our audit department and they can give them information about that. And I think the audit department, when they get in touch with them, will give them that contact information. Yeah. All right, I think that's.
Do you mind if I just add to that? I just wanted to clarify. So the repayment is only applicable to if there's been a settlement in terms of assets, not if they got a lump sum of child or spousal support, for example.
Thanks.
I think we'll go to the next page. Thank you. So I think we'll go through this one fairly quickly. I think our coverage questions are a little more clear than the rest of it. Good. Okay. So the first section is just sort of like, are you getting in touch with us because somebody's made a new legal application? Oh, can we go back? Sorry, Alice, can we go back to page 3? So yeah, that's if they've received a new application, a new court date, that information. Information about the opposing party. We need the opposing party's name for conflict checks, obviously. Whatever they can give us in terms of address, and then the history of the relationship. We just like to get sort of a bit of background and an idea of how long things have been going on. Then beyond that, they're kind of the questions that reflect our coverage. So have you been denied access to your child? Yes or no? So if they have been denied access, how long has it been ongoing? Is there an order in place that gives them access? What have they been doing to try and get access are kind of the main questions we're looking for answers to. Have they threatened to move away from the child? So is there a reason to believe that they are going to take the children and move out of province or out of the country? If so, why do they believe that might be happening? And then down the next page. There we go. So this is just the kids' basic information. I think that's pretty straightforward. Is there a parenting order? Is there a support order? So like what currently is in place? If there's stuff in place, we kind of want to know what is it that you want to change? And then finally, the last one, which is I think the most challenging, but really we are just looking for a yes or no. Has there been a history of family violence? Is there concern of family violence in the future, either for the client or for the child? If you can give us a little bit of background information about what that looks like for the client, that's always helpful for us. Like I said, more information is always better, but really we need to know, is there concern for safety? Andrea, did you want to weigh in on that one at all?
Oh, tomorrow we're doing a session on screening for family violence that will hopefully help make this part really, really easy.
We do understand that this one is a hard one to ask in some cases. We've got the list. We're really just looking for a yes or no though. And that is the family application.
And one thing I'm just going to add, Shannon can tell you, I have attachments to almost every single one of my applications. I write out what I think, what do they need to know in order to be able to approve this person? There's no such thing as plagiarism with legal aid. Copy and paste from the coverage guidelines and say, this is the legal issue. This is what's going on. Use their own language. It makes their lives easier when they can say, oh, this is coverable. Yes. Make it as easy as possible and lots of white space on the paper.
Just a couple last notes. If when you're sending in the online application in the email, if you could put the client's first and last name in the subject line and the area of law, that just makes it really easy, a lot easier for us to sort of figure out what's going on when we're sifting through hundreds of emails. Also, if it is urgent, don't be afraid to mark it as urgent. Don't try not to mark everyone as urgent, but really if it's urgent, mark it as urgent. If there's a court date coming up, like put it right at the top of the email or even in the subject line, like next court date is in 1 week and we need an answer on this. It just makes it easier for us to prioritize them. We know late wait times have been really rough this year. We've had a lot of staffing issues. Like I said, our call center has been crazy. We are finally, I think, getting to a place where we're back to full staffing and we're hoping that those wait times will go down. But marking things as priority and letting us know when court dates are or other reasons why things might be urgent, it really does help us.
I'm just wondering where we can find those guidelines. Where on your website are they?
Sorry, which guidelines?
Either of them. I don't recall seeing anything like that before. The coverage guidelines?
They're just on the financial representation. Sorry, the legal representation website. They're on the website. I just copy and paste from the website where it says legal representation. I mean, I don't do anymore, but I used to.
I don't think we lay out our entire IPP, which is, our intake policies and procedures. That whole thing isn't laid out, I don't believe, on the website. No. Right? And it's because it changes so often is one of the reasons. But that said, I mean, for those of you that are here, and some of you I've already been in contact with many times, you're welcome to just contact me or Shannon and be like, hey, I've got this situation and this isn't laid out in black and white. And there's a reason why things aren't black and white. And it's so that we can interpret the policy to best benefit the client or the applicant. So if we had everything in just black or white, I think we'd find a lot more people were being refused. So we take the policy and we apply it to each application individually. And so if you're looking on the website and you're thinking, oh, is this a case of family violence? Is this, is there really a denial of access? Just check with one of us first. And then we can, if it's going to help to expedite matters, or like Andrea said, write a letter along with the application, just explaining exactly what's going on. And then the intake worker, you know, is going to love you because they're going to have all the information without having to go back and forth with the client a million times for more information.
And just for clarity with the letter, legal aid has to say no to a lot of difficult situations. And so it's not about writing the saddest case. What you want to be doing is writing about the coverage. You know, there's a lot of emotional strip mining that the legal system requires. We should not be having to engage in that ourselves. So what I think the best thing that you can do is really learn how the coverage works, ask questions about coverage. Like, you know, Kirk has had many emails from me over the years where I'm like, what do I need to do about this? And he's like, oh, these are the questions that we would have about that. And so, you know, they are an excellent resource. The other thing about the IPP, you can ask legal aid for it and they will send it to you. And if they don't, I will. I ask for it every April because that's their new fiscal year.
So I guess we can close the application piece. And then use this handy dandy thing. So we already talked about the situations that we cover. Again, I think most of you are pretty familiar with our coverage guidelines. Every client, every situation, every application is different. So again, you know, our policies aren't black and white, and that's for a reason. And so that we can try to apply in a way that's going to benefit the applicant. Aside from our general coverage guidelines, we have what's called an exception review. So if on coverage, a case doesn't specifically fall into that neat little box of, you know, is there family violence? Yes, cover them. Perhaps sometimes it's just because the intake worker isn't totally sure if they should approve it. Sometimes it's because the intake worker really wants to give this person a lawyer. They really strongly feel this person should have a lawyer due to, you know, barriers, whatever those barriers may be. But their legal issues don't, like I said, fall into that tidy little box. So they would send the application for an exception review. And most of those come my way. So you're welcome to contact me if you ever have questions about those. And then we decide if, for the most part, myself or Deneen will decide if the case meets the exception review guidelines. Again, this is the exception reviews, and these sort of discretionary reviews are often based on funding that we have, just like every other organization. You know, if the funding runs dry, which can happen, sometimes we have to cut off some of these discretionary coverage decisions. But right now we're good, so get those applications in. And then we have, you may be aware of the limited representation contracts. So if an applicant, and for the most part, these are those cases where either a client is over our financial guidelines on income, but within like $1,000. So we have $1,000 discretionary limit. So they make a little bit more money, but they're dealing with something, they still need a lawyer. So we have this limited representation contract where the client can get, I believe it's still 8 hours with a lawyer for advice, direction, help filling out forms, some research as well. The lawyer can attend one of the meetings, family case management conference type meetings, Adina? Family management. All right. So they can attend those as well for those cases where there's no like coverable issues where we would normally provide representation. Like in years gone by, we never provided lawyers when it was strictly property division. So now we have this limited representation contract for those types of cases.
And Kirk, correct me if I'm wrong, but the limited representation, aside from divorce, it basically covers all other family issues. Do I have that correct?
It can be used for, yeah, for any legal issues if under the FLA, but just not divorce on its own. Oh, the divorce piece. Yeah, it can't be divorce as a standalone legal. So if somebody calls in or comes to your office and say, I want a divorce, and that's the only issue. And for whatever reason, you can't get anything else out of them, like property division, spousal support, anything like that. If it's just divorce, like they want it signed off on, they wouldn't be able to get a limited rep contract or a standard contract. But if there's other issues to piggyback on top of that, then they could get one.
Thank you. My question is, I believe that relocation orders aren't covered under the serious family situations. But what about, would that be covered under now your limited representation contract?
So yes, if you mean that your client is wanting to move away with the child,
Like overseas?
and get an order to allow them to move away, yeah, we could cover that under a limited rep.
Amazing.
Right. Yeah. And that's again, good question, because this is something that even intake workers around the province that have been around forever, it gets confusing because they see relocation and they automatically think, oh, relocation is covered. But technically right now, well, I guess as it's always been, we would only cover it under a standard, like a full family contract, if it's the opposing party that's wanting to move away with the child, leaving the client here and, with little or no access to the child. So if there's a risk that the opposing party is going to leave the province, or like from one end of the province to the other, we will typically cover them for a full contract if they're financially eligible.
I saw a quizzical face. So if the client wants to move with the child, it's limited representation. If the opposing party wants to move with the child, it's a standard contract.
So will the intake worker automatically bumping down to limited representation contracts have been refused, or do you have to reapply?
Good question. So yeah, they what we train, what Shannon trains the intake staff, and what we hope they're doing is that, and they are doing, they will interview the client first for a full contract. So let's look at this as how can we get you a lawyer for a full contract, full eligibility? And if at the end of the interview, or if after they've read through the application that you've sent in, for the client, they just can't find a coverable issue, and maybe they talk to the client, they just can't find that piece that's going to check the box, then they'll consider the limited, and so they don't have to reapply. No.
And if you have a client that has a limited representation contract, but they actually probably should have had a standard contract, my understanding is that's the lawyer that has to apply to change that.
Yeah. So currently, and I guess we've had these contracts for a couple of years now. When we got them, we didn't know how long they were going to be around for. Again, it was based on funding and everything like that. So the process still is that if the lawyer or the client gets a limited representation contract and they believe that the client should be eligible for a full standard contract, then the lawyer should email us. It's actually me and Deneen's, that's provincial supervisors at Legal Aid, blah, blah, blah. And then we assess. So it doesn't fall on the intake worker to sort of reassess the decision they've just made. It comes to us and we can review the case and the notes that the lawyer sends us. The clients will sometimes email us because the lawyer is too busy, or an advocate will email in saying, hey, can we, we don't think we discussed this in the first application, or this is a new issue that's come up. And then, if we can find coverable issues, we'll convert the limited to a full standard.
So advocates can call in or write in to change from a limited retainer to a standard contract.
Put my foot in my nose. Well, you know what? Yeah. Like, honestly, like the reason why we say the lawyer should email us is because the lawyer should have, in theory, a lot more information about what's being dealt with, because they've hopefully already met with the client. And is it possible to take, I was just going to ask if it's possible to take the slideshow off a timer. It's just, I think it's jumping because it's on a timer. Sorry, I should have said that before, but where was I? Oh yeah. So after the first meeting, the lawyers usually are in a good situation where they can email us and be like, you know what, if I go with this to court, now that I've met with the client, I know that, but obviously if you've met with the client, you have that probably same information as well. So yeah, if you email just Andrea, no, everybody, if you email us, you don't have to go through intake. So we tell the lawyers to email us at provincial supervisors, and then we'll look at it. Deneen does most of these conversion requests. And so right now, if she got the email from you, she's going to check to make sure that she has permission from the client. So if you need to, and you can always do a second one if you don't know if there was one before. If Deneen's going to have to talk to you about the case more, she's going to need that permission from the client, or she'll contact the lawyer, if she needs more information. But again, all we're looking for is whether now that maybe there's coverable issues, or if we could approve it via exception review. So we may not have, the intake worker might not have sent it for exception review the first time. Maybe maybe they weren't aware of certain barriers that the client has, for example. So if that comes up, then we might be able to approve it that way.
And one of my little super secret tricks that I'm going to tell you all is that when I need to get permission to talk to legal aid, I get my client. I have a form email. It's actually it's a signature option of mine, and it's write to intake at legal aid and copy my email and say I give permission for Andrea to speak to legal aid about my file, and vice versa. And then it has the client's full name, birth date, and phone number. Just so that way, if they used a different name or whatever happened, they can always find the client. And then when I see that email, I forward it on, and I label every single email permission so I can see it really easily, because I just have to search my inbox for the client's name and the word permission. And then I can forward it along to all following up correspondence. That way they get to see, yes, we already got it, because I can see that it was forwarded. It was sent to both of us.
Perfect. Yeah. So it doesn't have to be the form that's on the website. That's just there for ease of, if you find that helpful. But it can just be an email. And like Shannon mentioned earlier, it can even be a phone call, like from the client, as long as that note gets put on in our database that the client's given permission, and to who.
I think there's
question. Two questions there.
Is about kind of touching on the relocation. There might be a second part depending on your first answer. So if a client has multiple coverable issues, and then one of the issues is also that they want to relocate with a child, would that be something that can be included in a standard contract, or
no? So essentially, so our database has things that we can check off when we're listing, like you picture the paper application, but on the computer, we check it off. So the word relocation is literally only for when the opposing party is threatening to move away with the child. So what it means though, is that if they have coverable issues and they get a contract, and Adina can correct me if I'm wrong, but, and they get a contract and the lawyer helps them with their priority issues, their covered issues that we've given them the lawyer for, they've got the 35 hours under general prep and so on. If there's other legal issues that they want to help the client with and they still have hours available, they can use those hours for that, and bill LABC. What it means though is that you say that's the only outstanding issue, and they want to help this client to move away. If they seek extended family services, EFS, like more hours to help this client, it may or may not get approved, but that's up to Adina. Typically they will only approve more hours when it has like coverable issues that we've deemed are coverable.
Okay. So then my second part would be, even in instances, so a lot of the clients I work with live in really small communities where like staying in that community isn't safe, and they might have a protection order and other things, and staying in that community just might not be possible. In the case of family violence, would there ever be an exception, or could there be an exception for a client needing to relocate to a different town?
We would probably cover them on family violence. So we would check the family violence box. Right. We would check the parenting issues box, because, if the client is wanting to go back to court, and again, it's case by case, without specifics, but if there's been a history of domestic violence, and the client is wanting to go further in court and do some other things, it may come for exception review, and we may cover it on due to a history of family violence. They're not going to be covered specifically for relocation, right, but they may get a contract with a lawyer who can then bill as long as they have the hours. And
Okay.
What would
Thank
end up
you.
happening is that if the contract ran out, they wouldn't be able to get extended family hours if the relocation was the last outstanding issue, for instance.
So most often, if there's a history of violence and stuff like that, unless there's super like new good orders and everything's sort of taken care of, we're usually going to approve them one way or another. If there's a history of violence, and often it comes for exception review, and we'll approve it currently with budget because there's a history of violence. We don't feel this client is safe or in a good position to be going to court on their own against the opposing party, stuff like that. So of course, without getting into specific cases, that's.
And I think Isa has a question.
Sorry. So from my understanding, the standard contract clients have 2 years to use that. And then for the limited, they only have 3 months. Is that right?
So the contract dates are typically 2 years for standard. If it's a change of counsel situation, they may get the new lawyer may get the remaining of the 2 years. So the client still gets the full 2 years, but I may just confuse the situation. So yeah, 2 years. They get 2 years, and then if the case is ongoing, the lawyer can always request a stop date extension on the contract. So if there remains outstanding coverable issues, that's assessed by Adina's team to determine if there's there's a court date beyond the stop date on the contract, and there's still coverable issues, and they feel that more hours and a stop date extension are warranted, then they'll approve that. And sometimes if the 2 years is up and maybe there's no court date that's looming, they may just tell the lawyer to have the client reapply, and then intake will reapply. I've heard some folks out there say, it's like a one-shot thing, and that's definitely not the case. You might get your 2 years with a lawyer, and we have many clients that have had many contracts. Of course, once a client has had, 3 or 4, well, even after 2, but a few contracts with lawyers, we start to look at it, of course, a little, we start going through it a little bit more. We may send it to the family law team for their advice on whether we should approve it. But clients often get more than one contract, more than 2 years, because family cases can drag on, beyond the fact that it just takes forever to get through proceedings with COVID and everything as well, things being backed up over the last few years.
And Kirk, the limited retainer contracts, what's the stop date on those?
Sorry, is it 3 months or 4? 120 days. And currently, thanks. Thank you very much. Currently, they're not approving stop date extensions, right? Usually on the limited rep, because they're limited, they're meant to be limited, and that's the whole point of them. So in most cases, my understanding is that the lawyers aren't getting extensions on the stop dates. So the lawyer will spend the 8 hours usually pretty quickly with the client, and Adina can speak to that more for sure. Thank you.
Yes, the general policy is that the limited representation contracts are generally not eligible for stop date extensions, but we are assessing them on a case-by-case basis. And right now they are in place for 120 days. So that's the length of the contract. We are in the process of assessing both the length of the duration of the contract and the number of hours, and we'll provide more updates once those are available. So this is just the current situation: 8 hours of general preparation, 3 hours of court attendance for 120 days.
Thanks. We'll just leave a mic at that back table. Thank you for participating. That's great. Keeps us on our toes.
Is that from the date that you get approved, that the timer starts? Because what if it takes a long time to find a lawyer? For example, it's impossible to find a lawyer right now.
It's the date of the contract being issued.
So once
they could have been approved
hired.
3 months ago, but we're
Okay,
not
thank
starting the countdown until the day the lawyer gets the contract, basically. Do I have to go back?
That way, Kurt.
That way, towards the front. Oh,
No. So fun thing with these clickers are that we were controlling the other side slides.
oh no.
Are you serious?
before.
So we were controlling each other's? Amazing. Okay, good. There's always got to be something fun at an event. Okay. And we can certainly, I'm just looking at the time. So that it's already been an hour. We're a lively
Got
group
30
here.
minutes.
So we've got 30 minutes left. Lots of time. So CFCSA, just briefly, of course, we cover most CFCSA applications. We have the Parents Legal Centers all around the province, various locations, who provide assistance to a lot of the clients. And then for the rest of the clients that they aren't able to take for various reasons, they get referred out to lawyers in the community, so our tariff lawyers. And then when there's cases where perhaps there's a continuing custody order, you know, those final sort of orders, we send some of the applications up to the lovely Family Law Services Department, and they assess and do their merit screening.
And with MCFD cases, there is sort of, they still have to follow the threshold. If you have a client whose child is above the threshold, those are called JG applications. I'm going to make a plug that you can contact Rise, the FASL line, or any of us at Rise if that is the case.
Oh, for financial eligibility, yeah.
Yeah.
So for our finances,
On that
lovely
note,
little segue. Oh, wait, wrong one. Into our financial eligibility. So for CFCSA, since you mentioned it, the threshold is $1,000 more than standard family cases, criminal and immigration. So this is the current financial eligibility guidelines. It hasn't gone up a lot. It has gone up about $100 since last year, I guess. And so you've probably all looked at these guidelines at some point or another. I think now is probably a good time. I can let you know that there is a financial verification project happening. Management is looking into all of this stuff. Financial eligibility, guidelines, thresholds, due to inflation and all of that you're all probably very familiar with. So we're hoping, you know, some of these projects will be completed and we'll have policy updates by April.
huzzah.
Oh yeah, yeah. So not only will may we see, you know, changes to our financial eligibility guidelines. The income is one thing, assets are another that we're taking a really strong look at, of course. I say we, it's other people. One thing that came up was cars. The vehicle limit, like Shannon said, is $15,000, which doesn't get you much nowadays, especially like for people that have a work vehicle or something like that, or like a minivan because they have 6 kids and they need this minivan to get their kids across town to school. So we look at every single case individually, and I can say that we override most vehicles. If it's the family vehicle, it's the primary vehicle. Of course, if they walk in and, you know, I say of course, but like sometimes we do get applications where the applicant may have a couple vehicles. I had one, you know, had to deny them because they had an antique Mercedes or something. It was worth $125,000 and it wasn't their primary vehicle. I was like, I'm sorry, like I really can't bend the rules that much. Like we can interpret the policy however we want. But yeah, so family vehicles, you know, we try to fit them in. Yeah.
I don't know if you guys are looking for feedback on that process, but I understand at this point in time that debt load is not taken into account in the financial analysis. And I would think that, you know, consumer debt has a big impact on how income is used. And I would think that should be part of the analysis.
Yeah. So specifically on that, I would have to take that feedback back. Yeah, currently it's not. So if somebody calls in and you know, their income is over our limit. So every month they're bringing in actual income, not just like little bits of money here and there borrowed from family members and stuff, but actual income is over our guidelines. But then they're having to pay out a few $100s a month on a visa because it's maxed out. We can't take that into consideration currently. And historically, it's because, and maybe it is being looked at right now. I don't know. So I would have to ask management, but historically it was because it was considered consumer's choice. You know, you've racked up a credit card debt, and and it's consumer's choice. But I know that's like an easy sort of way for us to say, sorry, you're not eligible. But yeah, we don't consider the debt. Sometimes in discussing the debt though, we find out other things, like they've been spending money. They say they don't have any deductions, and we see all, this debt being racked up and they're paying back debt. But then we find out they were spending money on access. So they've been paying for gas and hotels and stuff to get visitation with their kids. We consider that a deduction. So if it's a monthly thing, it's an ongoing thing where they're spending, $500, I've seen it, $500 a month on gas just to get access to their child, then we would call that a deduction. Case by case, but yeah, we would consider that a deduction.
While we have you on the financial eligibility slide, would you mind talking a little bit about discretionary coverage, about those numbers and how they sometimes might vary?
Yes. So let me.
Or did I get ahead of you? I'm sorry.
No, I don't think I have a slide specifically on. You wanted me to say something. Yeah, before I jump to that, I want to mention this before I forget. So on the whole, providing proof of income, since we're talking about money, we do need some sort of proof to show how this person is supporting themselves. But what we've been working on, I think, for the past number of years, and what we're training, new staff, especially now, is we're trying to be as reasonable as possible in collecting that information. And especially with this financial verification project that's happening, that we should get some more answers before April. They're looking at what documentation is really needed. Like, what are other organizations doing? What's the government, like, what's everybody doing? What do we really need in our database? Because again, historically it was, transparency. Like if we get audited or something, we've got proof this person was on income assistance. That's why we, basically spent public funds on legal aid for this person. But now we're looking at, okay, now what documents are absolutely necessary? Is it all these bank statements, or can we just get a pay stub? Or, so breaking it down, and so hopefully next year we'll have some more information to share on that. But even right now, like, if a client's going to have a ridiculously hard time getting proof of income, let us know. Let your intake worker know. If there's challenges, talk to one of us and we'll see if we can get around it. We do waive, and I can tell we can waive proof of income in situations where we feel that it's absolutely necessary. So, of course, we're not doing it on every single application, because some clients do have the ability, or they can sit down with you at a computer or in another, with another organization and print off the bank statements and send them in, or whatever it is. But if especially in rural and remote communities, somebody has barriers, but that they're on income assistance, like, let us know. And like, we want to expedite these applications. We want to approve them. We want to get them off the desk. So, we're really working at, hopefully around the province, not making every single client, jump through the hoops that we've seen, as years go by. We're trying to make it easier. So, questions?
I've got a question. I'm wondering, I always feel like people are at an unfair advantage who don't have a locked-in pension and only have RRSPs for their retirement. Is that something that's being looked at?
I know the amount is being looked at. So the asset level for RSPs and all other types of assets. But I can make a note of that and ask, like, if they're actually looking at, so say they have $100,000 in RRSPs, and those RRSPs aren't locked in. Currently, we would have to include them as an asset. Whereas a pension that's locked in because they worked somewhere for a number of years, if it's locked in, it doesn't get included because they can't touch it until they're 65 or until they retire. That said, as a lot of your applications that you're working on are family in nature, we would override it if it's potentially a disputed asset in the family. So our current, I keep saying the word current, how I train people, how Shannon trains people, like if there's an asset that existed at the time of the relationship and now they're separated and they were married or in a common law relationship, we're going to consider it a disputed asset and we're going to override it. Because I'm not a lawyer, and I don't know if Adina's good. I'm not a lawyer. No, honestly, in intake, we're just trying to do this, we're trying to do a quick assessment here. And so if we know that this family was together, they were living together, and while they were living together, there was this RRSP, it may be in this one person's name only, but they lived together for however many years as a family. The opposing party may be able to make an application for, it may become disputed. And so from our point of view, from intake's point of view, is that we're going to override that asset because I know that at the end of the day, if there's a settlement, then, LABC will claw back whatever is owing to them if there's money left over. Now I know that's sometimes easier said than done. I don't want to say that's happening for every single case, but often with the RSPs, that's what I see. And I'm probably going to get, and then we're going to talk about discretionary.
I know. Just one quick note on the RRSPs. What about if you have a client that is a senior and this is all the money that they kind of have left, or you maybe somebody with precarious status who might have maybe a bit more than the assets allow for?
Yeah. So, and this is something that, intake doesn't see this every day. As you can imagine, a lot of our applicants, it's just the nature of the work, a lot of our applicants don't have any assets, but the ones that do come up can be quite complicated. And so sometimes you may find a client's being refused and then it ends up on our desk and we take a further look at it. But it's actually in our policy that if somebody is not employed and they're living off of an RSP, we can call that RSP income. And so we would average it out over a period of time. Now, if the person's 50, we're not going to average out a big RSP over the remainder of their life as income, unfortunately. I think that's probably stretching it a bit far. What I usually will do, because we don't see massive amounts. It does come up, but I'll average it over 12 months and see if that makes the client qualify. It usually does. Like I said, if they have no income and they're just living off of this RSP, or if they've lost their job and now they're going to have to start digging into their RSP as well. We, and I'm not a banker and I don't know much about that stuff, but we take off the 20% or whatever it is. So if we know they're going to have to dig into an RSP and they're going to automatically lose 20% off the top for cashing it out, then we take that off as the amount that actually they're going to have as an asset. Does that cover that? Sorry, I should move along. Discretionary coverage. We have discretionary coverage for family. So currently, if it's an issue where they, we strongly feel that this person should be eligible for a full family standard contract, not just a limited, because the limited contracts have that $1,000 room above our usual guidelines here on income. For discretionary coverage, we currently have $200. So with the budget that we have, we're allowed to go $200 over the normal guidelines on income. So, and you'd be surprised how many we get that a client comes in and they're $97 over. And the intake worker's I can't, how can I refuse this? They're only $97 over. They can't find a way to, we tell them to round a little bit, a couple dollars, but 97. So they send it for discretionary coverage. And if they have coverable issues, I can approve it as long as it's within $200. There was a time it was $500. And maybe who knows if that'll go up again. But it's down to 200 right now.
What about for this slide? Is there discretion on this?
Yes. on assets as well. So it's $500 right now. So I know that doesn't seem like a lot on assets when we're looking at like a bunch of bank accounts and stuff. I really, these again often end up on our desks, and I usually we try to get this person eligible. So if they're $600 over, well, are you going to be spending that money to pay your rent like in 2 days? Like that's going to drop your income down or your savings. We look at the bank account and we say, well, okay, sure, it looks like there's a bunch of money in the bank account right now, but are all the bills coming out on the 1st? And has this person over the last 3 months, 6 months, 12 months, do they always have $5,000 in their bank account, or is it just because they worked some overtime last month? So we, as painful as it is, sometimes we're going back. Okay, well, you don't qualify if we just look at these last 3 months, but what is the next 3 months going to look like? Like, okay, it was Christmas, so you worked crazy overtime at Future Shop. Okay, well, it's not going to be Christmas soon. So after Christmas, your hours are going to go down. Oh, you're only going to have part-time, or it was only seasonal employment. Like we're looking forward, if you get approved, what's your income going to be like in the next 2 years? And maybe it's going to be lower than it is right now because their contract is ending next month or their EI is ending next month.
Sorry, when you're filling out forms and you're looking at the household size, if a woman has her kids 50-50, you could still include them as the full household size. And when would that change? So like if they've got them 30% of the time or 25% of the time, like where do you change that?
It's actually 40. So it's only 40%. So as long as they've got them 40% of the time. So I think we usually say like at least three days a week, then we'll consider them part of the household.
What if they're being denied parenting time?
Yeah.
Can they be?
Yeah. If there's an order granting them, I'll go with what Shannon says. If there's an order granting them this parenting time, and it's, the way I look at it is it's, fairly recent, and they're being denied. And up until like a couple weeks ago or a month ago, they had the child with them or children with them, 40% of the time or more. And now the other party is taken off unlawfully, then we try to include them, or we can include them. I know I've had cases that I've talked to Andrea about, and cases where we've had to deny them because it was 2 years ago and the client hasn't had, and I know they were being denied parenting time, but it's been 2 years perhaps, and they haven't, financially been supporting then we get into the situation of, well, they're keeping up a house so that those 2 children can spend those 3 days there, even though they haven't had those 3 kids stay with them for like 2 years. Honestly, in a situation like that, I would probably go to Deneen. I would probably talk to Shannon. I would go to Adina. We all talk about these cases every day. And so I would, I definitely can't give you a straight answer. And again, it goes back to interpreting the IPP in a way that hopefully we can. I've had to deny some because it's been so long, and because the person, just hasn't been financially responsible for those other people in the household, even if it's, my nemesis. Student loans are considered income, minus tuition and books. So the amount that they're getting to support themselves, even though they're going to have to pay that amount back at some point when they're done school, we have to consider that income. So we try to take off as much as we can for, if we can get proof of what the tuition is going to be, what the books are, any deductions, like if they're having to pay, for BC medical, like things like that, deductions that we can look for. But it is considered income, the support amount of the loan.
answered this already under the debts, but if you consider the student loan as income when it's coming in, but then when they're making the repayments of that, that's not taken into consideration.
Correct.
Okay.
Financial verification project coming soon.
I'm mindful of the fact that we have about 10 minutes left.
Yeah. So, and I'm happy to, you're going to get our contact information, and some of you already have it. And I respond pretty quickly. So if any of you have experience with me. Yeah. So requesting a review of denial of legal aid. Andrea does this. Is pretty much her full-time job. And we overturn decisions all the time. So basically, client walks in, gets denied by intake, goes to somebody like you, and a whole bunch more information gets put together in a letter, and the client has 30 days. We stretch that all the time, but we prefer it not be 6 months down the road. Within 30 days of being denied, they send that letter to us, and that's one of my email addresses. So the file gets put into review, and we have 3 weeks to complete that review. So currently we're telling clients, we'll do our absolute best to get back to you within 3 weeks. I'm probably not going to lie, I was in Palm Springs last week, so we're probably sitting at closer to 4 weeks right now. So what we do is we review the application first, find out why the intake worker denied this person, and then we read the information that the client has sent in, that you've sent in. And like I said, quite often there's new information. If it's an issue that we believe because you've given us feedback or the client has given us feedback that maybe the intake worker didn't ask certain questions, then we use it as a training opportunity to go back to the intake worker, however long they've been with us, and say, hey, I'll talk to them directly, or I'll get one of their team leads or supervisors to, just to review how intake should go and if they've missed something, right? But often it's this new information that we get, we overturn the decision and get the lawyer appointed. Question? I
just want to add something here. So my general practice as an advocate is if a client tells me that they've been refused legal aid, I contact legal aid, and I get that permission email and I send it off to Shannon, I send it off to the van intake supervisors, and I say, my client told me that they were ineligible. Can you let me know if it was not coverable, or and then I have a whole criteria. If anybody emails me, I'll tell you my list of questions I ask about financial eligibility. They send me back an answer, and then I ask my client. So they said that your monthly income is $4,000. Is your monthly income $4,000? They say no. And I say, let me see those bank statements. And then I do the math myself. And then I write back to legal aid, or I explain, oh, actually it was $4,000, but she has since lost her job and is ineligible for EI because she actually had that job for 2 months. And then Kurt gets that follow-up letter.
Yeah. And those are the super easy ones, of course, because they come in and it's, thanks to all of you, we get this tidy letter from somebody that totally lays out the situation, what's going on. And we're excited because now we can just say, yes, you're approved, and get the intake worker to, because that's what we want. So, as we know, sometimes when clients call in or they go into an office to apply on their own, they're not able to, due to all kinds of reasons, to really explain to the full extent, the situation. And the intake workers, however many years they've been working with us, they may be new, or however much training they've had, sometimes that right question might not come up, or something to trigger the client to explain further, in more detail, or what's happening with their finances. And so sometimes it does take that extra step to come for review. And again, like Shannon mentioned with urgent applications, if you mark it as urgent, courts next week, the client was denied yesterday, is it, possible to get this, then I can expedite it and get an answer to you quickly. Yeah. And, this is probably one of the last slides. So working together. Cheesy, but so ultimately, we're all assisting in large part the same clients, and so, you know, I think Shannon and I can speak for the rest of the folks in intake, in, of course, thanking all of you, because you're helping the clients to get to us and to apply and to provide the information ultimately that we need to make a decision. And I hope, again, as Shannon mentioned, that, you know, we're kind of staffed up to levels right now. You know, the call center volumes have literally doubled and they haven't gone back down in the last year. So imagine, you know, hiring 10 new people and getting them to a level where they can actually take these applications, and then half of them go to law school. So then, you know, they all want to go to law school. So I did too, I failed. I think we're at a good place right now. And so it's good timing for us to be here and to be like, okay, expectations, you know, your client should be getting an answer within a week or so. You know, we used to say 3 to 5 business days. That's pretty quick right now, not gonna lie. But ultimately, if you email me or Shannon, you're gonna get an answer pretty quick. And then we can at least let you or the client know, okay, listen, like we received 100 applications yesterday for this town or something. And so maybe it's gonna take a couple extra days, but we can at least tell you and give you an idea. But I think we're in a good place to say, you know, in the new year, like the expectations for timeframes and everything should be back to normal. Should be, you know, unless everybody ups and goes somewhere else. So again, thank you for everything you do. And
just on the topic of working together, I deeply value the relationship that I have with Legal Aid and all the amazing staff there. Like, I really think that this is a collaborative approach. I think that sometimes as advocates, I know that early on in my career, I felt like I was butting heads. But I think that it's actually we have a lot more in common. What it is it's how do we help bring out the best in each other? You know, and that's is where I think that we can do our best work as advocates, is to help Legal Aid to understand our clients' situations, let them know also about issues that you're seeing. Kirk, Shannon, everybody there has heard me lament on issues, you know, and that's how we've had really great collaborations. Like the third-party legal aid applications came out of me saying, well, right now we have clients going and getting really upset because they hear no, and then I have to spend an hour and a half writing a letter that goes to Kirk, and then Kirk answers it and says yes. That seems inefficient. And that's how we got the third-party applications. And so, you know, I do think that there's a long history of collaboration, and I just want to really sort of frame it that way, because I know that sometimes it feels like, oh, we're getting no's and but I really respect and deeply appreciate the amount of effort that they put in.
Thanks, Andrea. I think on that note that there has been a culture change. I think that's I think it's a very, you know, cheesy saying. But when I started like 15 years ago, intake was a different place. The organization, everybody's organizations were different places. Funding was much different. And I think, you know, we're in a place now where it really feels like, you know, intake is we're wanting intake, and intake is wanting to, like you said, work collaboratively, because we want to approve, like we do want to approve people. We have the money, we need to approve people so we can spend the money. If they're eligible, they should be getting a lawyer. So we're trying to make it as easy as possible for the clients and yourselves to assist the clients. So thank you for having us. I'm going to be going and getting on a ferry. This is Shannon and Andrea. Andrea, I don't have your contact information, but I think they all have it.
Everybody has it.
And that's my phone number, so you can call me anytime. And both of me and Shannon's emails. And honestly, like I've said this at numerous conferences over the last decade, and I probably only get emails from like a very small handful of advocates around the province. I really encourage you to contact me, because if there's a situation in a small community, we don't know about it unless somebody tells us. We have local agents around the province. We communicate with them regularly, and the lawyers. But, you know, if you have feedback for us, like I said, we supervise those communities. So let us know, or if there's a challenge with an application, just talk to one of us. And it's usually something I can pull up and say, oh, well, she just missed this one little thing, or they, the client's actually eligible and there's actually been a lawyer appointed, but the information was mixed up somewhere. And yeah, so.
And when I see a systemic issue, I won't email it because I don't like it to be in writing, but I will phone Kirk. And I will say, this is a problem that's happening at this local agent. This has happened this many times. Please don't tell them it came from me. But it is good feedback for them to have. And I know that Kirk takes it on and does as much as they can within that capacity.
We try.
Yeah.
Okay. I think we're
at time.
2:59. If you have questions, just email.